Dear students, we are here to discuss the final chapter of life, death. Preparing for your ultimate demise. For, as we said in chapter 3, the only two things certain in life are death and taxes. And we've already done taxes, so now is the time for us to do the death thing. But to be truthful, folks, you millennials, who knows? They might have this immortality thing worked out in 80 years, so I don't think we boomers have a chance. But that doesn't mean you millennials might not. We'll see. If anything, I read an article that Google's working on it, and they're pretty cool. They're pretty smart, those boys and girls up in Silicon Valley. Let's get started on slide 37. Your estate consists of everything you own. So an estate plan is how you set up to administer and distribute your property, everything you own. During your life, those are called gifts while you're alive. Legally, that's what they're called. When you give money while you're alive, it's a gift. Or after your death, that is an inheritance or a bequeathment. And many people believe that estate planning is for wealthy individuals. Well, the truth is, it is not just for the wealthy. If you own a home in the state of California, if you have children, no matter where you are, you need estate planning. Now, folks, I want you to remember this as we go through this presentation. Nothing in this presentation is meant to be construed as legal advice in the state of California or anywhere else. I am 3 years of law school and 1 bar exam from being able to give legal advice to anyone. How long is law school? It's 3 years, right? I took a business law class 1,000,000 years ago, and you don't want to listen to me for legal advice. Don't go to the lawyer and say, Mr. Brown says I need a trust or a will. No, don't do that. Go to the lawyer and say, ooh, Mr. Pano says I need to talk to a lawyer about a possible trust. And the lawyer will say, oh, Mr. Pano is very wise. $1,000, please. Yeah, right. Thanks a lot. Estate planning includes both building your estate, the accumulation phase, and then transferring your estate upon your death. So that's what we're going to discuss, the final chapter of life. Slide 38. Most people give little or no thought to putting their personal and financial affairs in order for their families that survive them. If you have a child, you really need to name a guardian, folks, because if you don't, as we're going to see, right, the courts do it for you, and for the distribution of your personal belongings. And the demands of daily living can keep people from thinking about death. Plus, it just ain't fun to think about your own mortality, is it? To think about a time when you ain't gonna be here. Well, we'll see what you millennials... Well, I won't see what... You'll see what you millennials in 80 years, 100 years. Slide 39. What the experts and what we suggest to you to do is plan while you're in good health. Because many people procrastinate until some life-threatening illness or near-death accident scares them into acting. And estate planning is especially important for non-traditional households and businesses, such as unmarried partners or people in same-sex relationships. But now they can get married in the state of California and 30 other states in this District of Columbia. Married people have far more rights and responsibilities, and property is not a problem, and excuse me, and if somebody's very, very ill, there's not a problem. The spouse is allowed to come see them, is allowed to make decisions, or not always allowed, depends on the documentation. But if you're not married, then it can be a real problem. That's why you especially need estate planning. And as we said back in chapter 10 with life insurance, business partnerships have special relationships and special needs, and one of them is estate planning. What happens if one of the partners dies? Then the surviving partner or partners, their livelihood could be in trouble. So they especially need to talk to lawyers, qualified, competent, board-certified lawyers about estate planning. Slide number 40. Speaking of lawyers, should you hire a lawyer or go it alone? What did we say about taking out your own appendix? Get a good referral. And the good lawyers that I've talked to who do estate planning will tell you that their job is to minimize. They can't eliminate. But to minimize the ill will and just nastiness that sometimes comes out after a person dies. It just brings out the worst in people when there's an inheritance to be fought over. And so the good lawyers, the estate lawyers, will tell you we're going to do our best to minimize that. They can't guarantee that there won't be chaos and bad feeling and legal action, but they will do their best. If you need a will in the state of California, and the lawyer is going to decide whether you need a will, and will hint at what you'll need later on, it's going to be about $200 to $300, maybe $500. If you need a trust, that's still advertised at $500, but I have a hard time believing that. Most lawyers now are charging at least $1,000, $1,500, and I've heard people being quoted $2,000 to have a trust set up. Now, who needs a will? Who needs a trust? Again, it is the lawyer who makes the ultimate recommendation. But we will give you information. We won't recommend anything here, folks, about what is important in the state of California. There are some people who will go it alone, folks. I don't recommend it. You can make a mess of things. And one of the weirdest things about estate planning and doing it yourself is that you probably won't know if you screwed up because you'll be dead when the problems arise. Exactly. But there are many books, software, pre-printed forms, and now the infernal net. The oldest and most respected website is called nolo.com. And this guy started this many years ago before the internet. He's won all kinds of accolades for trying to help people who are on a tight budget and can't really afford lawyers to help them with their legal issues. And now there's Do Your Own Will. H&R Block's getting into the act, and I love this name, LegalZoom. And that's your assignment. Optional bonus assignment for Chapter 14 is to go out there and just do your best to decide beforehand. Again, the lawyer will make the ultimate decision whether you need a will or a trust, and then go get a quote on either one or both. Don't take out your own appendix, folks. Get a good referral. And I have the names of some very good lawyers in the Chula Vista area that if you're interested in. But, there are many good lawyers out there. There are many not so good lawyers, just as there are many good professors and not so good professors, and many good doctors and not so good doctors, and many good trash collectors. Oh, I'm sorry, environmental engineers. And so, and we know. Did I tell you any lawyer jokes? In the face-to-face class, we throw out a lawyer joke every once in a while. And there's reasons why there are lawyer jokes, folks. Yes, there are reasons why there are lawyer jokes. So slide number 41. What does estate planning involve? Well, you're going to be creating, reviewing, and updating your will, trust, any other documents that you need on a regular basis. Especially if you get married, divorced, move to another state. Normally, when any of these happens, you throw away all the other documents and then create them from scratch. But a codicil, which is a kind of a silly name. But that is a document which is used to amend an existing estate document if something big hasn't happened. You need to name an executor for your estate, and we'll discuss that in a bit. And in the state of California and other states, you want to consider creating and managing a trust or trusts, not to be construed as legal advice. Let the lawyer make a final and informed and professional recommendation and pay him accordingly. Prepare a letter of last instructions. Well, we'll discuss this. It's not a legal document. It's just to help people do the menial chores. And organize current financial records and documents and let family members know where they are. Yeah, because you'll be gone. Slide 42. Here you go. Make an inventory of your estate. Does this look familiar? Yeah, there's a reason why we did that cash flow statement and we did the net worth statement. The inventory of your estate is your net worth statement. So your executor, your successor trustees, your lawyer can look at the entire estate in that one sheet of paper and know where everything is and what they need to go locate and who to contact and the like. I have all the telephone numbers on the net worth statement so that they know exactly who to call and find out about these accounts and business interests and whatever important documents and the like. So use that net worth statement. Slide 42. Let's talk about a will. Now the will is what you hear in the movies, the reading of the will. Well, the will is a legal declaration of a person's mind as to the disposition of his or her property after death. In other words, who gets what. Marriage and divorce affect your will, and depending on the state you're in, marriage may revoke your will. If you marry or divorce, you need to talk to a lawyer. You're probably going to want a new set of estate documents anyway, but that's the lawyer's decision. In the state of California, the legal cost to prepare a will, $200 to $400. Once you get up to about $500, you're probably looking at a trust, but that's for the lawyer to decide. And although I don't personally recommend it, dear students, in fact I recommend against it, you could probably do your own will without creating a legal nightmare for your heirs. But that's not a guarantee. You could easily create a legal nightmare for them if you don't know what you're doing, and most of us don't know what we're doing. Slide number 44. Intestate and probate. Well, these words sound kind of weird, kind of naughty, don't they? Intestate. Do you want to die intestate? He died intestate. Oh my goodness. Did he have his clothes on? No. It just means you die without a will. The state distributes your assets. In other words, if you don't have a will, the state you're in has a will for you. The state will decide upon a guardian for your child or children if you have them. This can be very complicated if you also have a blended family. In other words, children from a previous marriage. Yeah, it can get real messy, folks. So you don't want to die intestate. Unless you hate your heirs. Unless the little twerps gave you nothing but heartache throughout their entire lives and grew up and told you that your life sucked. And you said, you're absolutely right. I've had you, didn't I? No. That's bad. I apologize. But no, don't do it. Don't die intestate. Probate. What's that? Well, probate is a process by which the probate court validates your will and makes sure that your debts are paid before the assets are transferred to the heirs. And in some states, California being one of them, many people will do their best with the help of a lawyer to avoid the probate process by using what is called a living trust. There are other types of trusts that we'll see, but the living trust is by far the most popular in the state of California and other states. In some states, you don't have to worry about it, so you will find that out if you move to those states. Slide 45. An executor. Choosing an executor is a very important task. Before you simply choose your brother or your son or whatever, find out if they're willing to accept this major responsibility. Because if there are several children or other heirs, the executor is the one who's going to really get dumped on. They're going to be the one that everybody hates. if it's ugly, which it often is. Find out if he or she is capable and trustworthy. If you don't name one, the court will name one for you. Obviously not the best alternative. Being an executor is a serious responsibility. Therefore, choosing one is even more serious. Consider choosing co-executors, your attorney, or a trust company that the attorney recommends, and then a friend or a family member. Make provisions to pay the friend for their time. I've seen numbers $50 to $75 an hour. You see, they can do the legwork. They can run around and get the documents and get these things signed off and the like. And the attorney will make sure that the important tasks are done correctly at, $200 an hour. And as we said, there are reasons why there are lawyer jokes. I mean, that's a lot of money. But what did we have before we had lawyers? How did we settle disputes and the like? Right, pistols at dawn. So I'll be happy to pay the lawyer $200 an hour to not be shot at. Slide 46. What are the responsibilities of an executor? They take control of the assets. They get your checkbook. They file an inventory of assets and liabilities with the court. They sell any assets if necessary to pay off liabilities. They distribute the assets then based on the instructions in the will and turn around and make a final accounting to the court. So you see, they have enormous power. And of course, there are countless stories of abuses of that power. So choose carefully. And this might sound maybe a little unrealistic, but it isn't. You don't want somebody who will succumb to literally stealing from the estate, because it just happens so often that people just they don't think they're going to get away with it, and they just act as if the assets are theirs, even though the assets might be promised to a different person, an heir, a different beneficiary. So make sure you choose somebody who's not tempted easily. Now, if you think I'm crazy, ask a lawyer, an estate planning lawyer, for some of their horror stories. And I'm sure I'm nowhere near as I'm not making it sound as bad as it really can be. Okay, I'm sure of that, because I've heard some pretty horrible stories that I just can't believe. But that I'm not an estate lawyer, so I don't know if they're true or not, but I take them for their word. Slide 47, selecting a guardian. Now here, this is, folks, some of you don't have very much assets, but you certainly have children. And even if you don't have much assets, if you have a child or children, you still need at least a will to at least name a guardian. Remember, this is not to be construed as legal advice. Please talk to your lawyer. The guardian assumes the responsibility for providing the children or the child or children with personal care and managing the estate for them. Be sure the person is willing and able to raise them. See if their values and child-rearing practices match yours. My mother is now gone, as they say, God rest her soul. But we did not make her our guardian for our son, and we never told her that. She just assumed she was going to be the guardian. But we did not think, and we were pretty sure of this, that our son and my mother, his grandmother, would have gotten along very well. It would have been a test of wills So we chose somebody else. So, and again, if you don't choose somebody, right, the court is going to do it for you. So please choose a guardian. At the very least, talk to a lawyer about choosing a guardian for your child or children. Slide 48. Now we're going to take a little bit of time and discuss a few documents that really are not part of estate planning, but often the lawyer will throw them in, or if you need this special situation, you will talk to a lawyer about it. And one of the first ancillary documents that often goes with estate planning is the prenuptial agreement. The prenup, right? This is a document that waives rights to each other's property that was acquired before the marriage. What you're essentially doing is agreeing on a settlement before you marry, if you should then subsequently divorce. Now, you're thinking, you're planning, you're hoping to marry this person and live happily ever after for the rest of your lives. So you really want to discuss divorce? Well, it can be very important for couples who already have children or assets or both. So at least talk to a lawyer about the advantages and disadvantages of a prenuptial agreement before getting married. What's the most important financial decision you're going to make in this lifetime? And if your would-be spouse refuses to even discuss a prenuptial agreement, that should serve as a disturbing omen. Don't say I didn't warn you. Indeed, I want these words to be ringing in your ears when you're standing up in front of that congregation, the assembled multitude watching you say, I will, I do, I'm in trouble. Slide number 49. Oh, by the way, some people think, oh my goodness, he must really hate his marriage. And they come up to me and they say, are you happily married? And I say, oh yes, my wife told me to tell you that we are very happily married together. Slide 49, a living will. This is not really a will. I don't know why they call it a will, but talk to the lawyers. That's why they'll tell you why it's called a will. But it is more the pull. They should call it the pull the plug document. It provides for your wishes to be followed if you become so physically or mentally disabled that you are unable to act on your behalf. For example, you may be in what is called a persistent vegetative state. Now, some of my students are already there. I'm pretty darn close. But no, a coma, they don't know what to do. So about 10 years or so ago, there was a national case of a woman in Florida who had been in a coma for 16 years or something, and her husband finally said, look, this is enough. The doctors are pretty sure that she's never going to come out of it. It's time to pull the plug. Her parents, on the other hand, said, no. We want you to keep her alive no matter what. And ultimately the court sided with the husband because that's my understanding is the spouse has more say in these matters. If she had had a living will, then there would have been no problem. The hospital would have said her wishes were she did not want to be kept in a persistent vegetative state for an extended period of time. So you decide what you want. If you talk to the doctors, they'll tell you, sign the darn thing, okay? There's no way to live. It's time to move on. Discuss your living will with those close to you. Sign and date it before 2 witnesses. Give copies to those who are close to you, and it requires careful thought. Actually, it's a no-brainer. Oh, I'm so sorry. I couldn't help myself. It's a sickness, I know. Slide 50, power of attorney. Now, what's this? Those of you who've been in the military and have gone on deployment know what this is, because before you leave, your commanding officer shoved one in your hand and said, sign this. It's a legal document authorizing someone else to act on your behalf. Now, it can be very limited, such as just to the car that you own, or you can give the person a great deal of power. You can give them your checkbook, and they can do with it what they will. They're acting on your behalf. So, right, choose carefully who you give power of attorney to, if you need to, because most people don't need that power. The durable power of attorney for health care is the same idea, but it is for healthcare decisions. If you are unable to make decisions regarding your health care, this authorizes someone else to do it for you. My wife and I, well, I'm the power of attorney, and she and another person are the durable power of attorney for healthcare individuals. And even with these documents duly processed by a qualified, bar-certified, high-powered lawyer, there's still quite a bit of resistance from people, because I'm sure people in the financial world, in the healthcare world, I'm sure there are lots of horror stories that they could tell you of things that have gone awry. So even though you are giving these people the power to do with your finances and with your health, with their health care, there's still people looking over your shoulder because they remember the last time somebody came along with one of these things. Slide 51. The letter of last instruction is not a legal document. It's not legally enforceable. It's just there to provide heirs with information, such as your funeral preferences, who do you want notified, where are certain items, who gets personal effects that are of little value. For example, your niece loves that lamp or whatever quilt, and instead of putting it in the will or putting it in the trust that this person gets it and having the lawyers and courts to deal with it and charging you their hourly rate, you just make sure the executor or the successor trustees know that this person gets this personal effect, and just don't let the courts deal with it, because it'll take forever and it'll cost more than the darn thing is worth. That's the letter of instruction. 52. Okay, slide 52. Now we're ready to finally stop dancing around this thing called a trust and talk about what it is. A trust is a legal arrangement. It is a thing, a structure in the legal world, through which a trustee holds your assets for your benefit or that of your beneficiaries. The trustee takes care of or manages your property. But in some trusts, you are your own trustee. And the trustee or successor trustee, if you're your own trustee and have gone on to your great reward, the trustee or the successor trustee distributes your assets to your heirs from the trust after you die according to your instructions. How does this work? Well, you take all assets, well, maybe not all, but the major assets, out of your name and put them in the name of the trust or trusts. Huh? What? Why? Well, we're going to see that many people do these, create these for various reasons, but one of the most popular in the state of California and some other states is to avoid probate. And we'll see how that works in just a few slides. But before we do that, let us say that trusts are tricky. Some people will create them for themselves. You can do this, dear students, but if you screw up, oh my goodness, oh boy, I don't want to be there. Because your actions can result in outcomes that range from typically useless to potentially disastrous. Now, how do I give you a for instance? It's not the easiest thing to describe. But what often happens is that somebody will follow the paperwork or the software program or the online website to create a trust, and they'll create the trust, and they'll go down to the county courthouse, and they'll file the trust with the filing fee, and the clerk will take it, and bingo, the trust has been created. But what they then fail to do is fund the trust. They fail to take the assets out of their name, or they don't do it correctly, and put it in the name of the trust. So what they did was useless. It didn't hurt anything, but it didn't help, and they won't know because they'll be dead. But if you create the wrong trust, or you put the assets in the wrong trust, or do it incorrectly, your actions could be disastrous. Because now you can't touch your own assets. You can't turn around and sell your house. So, I'm not a lawyer, so maybe I didn't describe it correctly, but this is my understanding of what can happen. So what are you going to do? Right, we pay the lawyers $1,000 to build a trust for us and fund it correctly. And I think that's you'll see still advertised $495, no extra costs, complete trust. I don't think it really is true. I think they'll charge you $495 to create the trust, and then they'll charge you $500 to take all the assets and put them in the trust. See, I think that's I haven't called them and found out, but you'll see still a trust advertised for that much, and I think that's the come on. But ask them, call them up, check them out. Some of them are in this advertisements in the San Diego Useless Tribune. I'm sorry, the Union Tribune, right? The Union Tribune. Slide 53. What are some of the possible benefits of a trust? Well, in California, many people, as we said, use trusts to avoid probate, and we'll discuss that in just a bit. They can be used to reduce estate taxes, and we'll discuss estate taxes in a few slides. But these are people who have over $5.5 million or so. A trust can be used to free you from managing your assets, or you can be your own trustee and you manage your assets, and then a successor trustee, after you pass away, takes over. They can provide income for a surviving spouse who is maybe not necessarily very good with assets or dependents. Trusts can be extremely helpful for people whose children or grandchildren are either disabled or emotionally unprepared for a windfall inheritance. We'll discuss windfalls in a few slides also. So, look on slide 54 at the various types of trusts, and folks, this is not an exhaustive list. This is just some types of trusts that are out there. Now, would you know which one to pick? No. Well, maybe. What? I guess I can figure one out. What is the generation skipping trust? I think that must mean you don't want anything to do with your kids and you want the grandkids to get everything? I don't know. Look it up. No, I'll tell you which ones are the important ones. Here they are, folks. Slide 55. The Revocable Living Trust, and in some cases its cousin, the AB Trust, are very common in California. The Revocable Living Trust is actually called an inter vivos trust, which I'm pretty sure means while you're still alive. And in the state of California, it is used to avoid probate and possibly reduce your estate taxes. If you are a California resident who owns property or has any substantial net worth, your estate will most likely benefit from some sort of living trust. Now, again, this is not to be construed as legal advice in the state of California. Go talk to the lawyer. Legal fees range from, again, people are still advertising $500, but I think that's a come on. And I've heard people quoted $2,000 now for these things. Please do not try to do your own trust. Why? Let's say it again. If you screw up, your actions can result in outcomes that range from useless to disastrous. So don't do it. Go talk to a good lawyer. Slide 56. Here you go. Finally, Piano, you're telling us why we need this thing. Well, in the state of California, they have minimum probate costs. For a few hours of work, if your gross assets value of your estate is $200,000, which means you own a small condominium, the lawyers get $14,000 for a few hours worth of work. If you have a nice house, $500,000, they get $26,000. Sheesh. If, on the other hand, you have a living trust set up correctly by a competent bar-certified lawyer, then the probate fees are $0. So let that sink in for a minute. We pay the lawyers $1,000 to $1,500 before we're dead, so that our heirs don't get hit with a $26,000 probate fee. And I know somebody at Southwestern who did not do it. He did not build the estate documents, and his son and his ex-wife were stuck paying a huge probate fee to some lawyer for doing just a few hours worth of work. There are reasons why there are many lawyers. Did I tell you the lawyer joke? I don't know if I told you the lawyer joke. What do you know when you see three lawyers up to their necks buried in concrete? Up to their necks. What do you know? They ran out of concrete. I look, folks, I like lawyers. I like I said, I don't want to be shot at, and so lawyers have helped me. A couple of lawyers have helped me immensely in the past, and so I'm very happy for them, just as a couple of doctors have helped me in the past. But this is the kind of thing that gives all lawyers a bad name, right? This is one of the reasons there are many. How many lawyer jokes really are there, folks? There's only 2. The rest are all true stories. Slide number 57. Whoops, I hit the wrong button. I'm sorry. Slide number 57. Okay, federal and state estate taxes. Well, California doesn't have an inheritance tax. It's one of the states that does not have it. And it's funny, some states around California say, Kai, when you retire, come to our state. We don't have an income tax. We don't tax you like California. No, we wait till you die, and then we hit you with a state inheritance tax. But the feds do have an estate tax. And some people call it the death tax. Well, the estate still, and if you have a trust, still has to file federal income taxes, and that's part of the professional fees that your estate will have to pay, and your trust will have to pay after you've passed away. The gift tax is something that people don't really understand. They just don't get the idea. But the idea was to keep people from avoiding estate taxes. You can give anybody, as many people as you like, I think the number is still 14,000. You can give them $14,000 per year in perpetuity. And if you're married, double it, because each person in the marriage can give that amount. But if you give more than that, then you have a choice. You can pay a gift tax. Now, not the person who got the gift, folks. You. And we'll discuss that why in a minute. But you, as the gifter, not the giftee, have to pay the tax. And people go, what? Well, not really. Most people then say, look, I'm giving something of value, $50,000, $100,000, and I'm not going to pay the gift tax. I'm going to choose to reduce the amount that I can exclude from my estate when I pass away. Huh? Wait, we're going to see a slide about this in just a minute. What did we say about tax avoidance versus tax evasion? There will be some unscrupulous individuals who will do their best to convince you that they can help you get around the estate taxes. Be careful. You won't know if you screwed up because you'll be dead and your heirs will be left with the mess. Many people, if they are going to be hit with the estate tax, will choose to give charitable bequests, which reduces the size of their estate and gives them a tax break while they're alive. They'll use what are called charitable remainder trusts, or just donate appreciated assets to charity. There are ways to get around the estate tax, folks. There really are ways. Virtually very few people will ever be hit with the estate tax. Sometimes, if they have not planned ahead Assets will need to be sold to pay for the tax, but this means the person really has not talked to good lawyers about how to get around, or just read. It's not that hard, folks. I can figure it out. If I can figure it out, they can figure it out. Slide 58. Here's how it works. There is a federal estate tax exclusion amount that we see going up with inflation. In 2015, we see that the first $5,430,000 of assets are excluded from the estate tax. That means you can bequeath to your heirs $5,430,000 if you passed away in 2015. Of course, if you're married, double that. Right, exactly. So the married couple can give $10,860,000. After that, they start to get taxed. The estate starts to get taxed, and it goes up to 40%, which is a lot of money, folks. So before you die, if you're in this rarefied air that you have this much money, you want to work to use trusts and charitable remainders and charities to reduce your estate. The Republicans, every few years, jump up and down and scream and holler, and they want this to be repealed permanently. They refer to it as the death tax. And there are about 18 families that are very, very wealthy. Now, these people have tens of billions of dollars that are really pushing to get rid of the death tax. And, of course, they fund the Republicans' campaigns. So the Republicans say, okay, let's get rid of it. But that Bolshevik communist liberal, no, he was a conservative, Winston Churchill, described the estate tax as a certain corrective against the development of a race of idle rich. In other words, we don't want to go back to the Middle Ages when you had people who would pass down tremendous wealth from generation to generation to generation, the aristocrats who looked upon the hoi polloi with disdain. Folks, it affects about 0.12% of all Americans, far less than the top 1%. You've heard of the top 1%? No, this is the 0.12%. And here's a wonderful quote that's been attributed to two different individuals, but let's read it. Our ideals, laws, and customs should be based on the proposition that each generation in turn becomes the custodian rather than the absolute owner of our resources. And each generation has the obligation to pass this inheritance on to the future. So I'm calling you out, folks, those of you who are fighting to repeal the estate tax. Do you really want to go back to the Middle Ages, the feudal times when the chief prince founded a new states? Yeah, no, I certainly hope not. I think it's very backward thinking, but that's me. You might think, oh, you communist, socialist, liberal. We are not supposed to live in a plutocracy. We're supposed to live in a meritocracy. But enough said. Slide number 59. Speaking of inheritances, the greatest transfer of wealth in the history of the world will begin shortly. Approximately $41 trillion throughout the next 40-50 years. And if these estate tax folks don't get their way, the ones who want to repeal it, it'll be $6 trillion in taxes. These are people who have tens of billions of dollars. And I really liked Warren Buffett, who said, I want to leave my children enough so that they can do whatever they want, but not so they can do nothing. And he originally planned to allow his wife to do the philanthropy, to give away all the billions that he has amassed throughout his life, because he said, look, it doesn't matter whether we give it to them now or we give it to the charities later. There will always be charities in need of help. So while I'm alive, I want to build the capital. And once I go, then when I go, my wife can do the philanthropy. Well, his wife passed away before he did, which was, not what he planned. You often think your wife, if you're a man, think your wife is, because women live longer than men in general, right? And so he has started. In fact, he's using Bill Gates's foundation to funnel his money through. And Gates, I think this is another cute story. I think I might have told you this back in chapter 6. In the mid-90s, when Microsoft was exploding and Bill Gates was worth first a few billion, then tens of billions of dollars, and one reporter said, well, what are you going to do with your money? Who are you going to give it all to? And he said, I'm not giving away my money. He didn't even know how much money he had. He was more worried about taking over the world. And they said, no, you don't. And there was a brief firestorm, and they said, Bill, you're going to give away your money. I am. You have too much money. You can't even spend it all. I can't, and then the next week they said, no, Mr. Gates meant he wasn't giving it away. Yeah, he will, of course. And he is. He's right now, the Bill and Melinda Gates Foundation has funded all kinds of great causes all around the world, because there's tens of billions of dollars for him to give away. 2/3 of these inheritance will go to people who are already wealthy. Are you one of the lucky ones? Yeah, me neither. So, but if you're one of the lucky ones who will be the recipients of an inheritance, slide number 60, how do you deal with a windfall? You suddenly receive $300,000 or $500 or $800 or $1.2 million or whatever. You think now you are one of the rich and wealthy and you are set for life. Or are you? The average Joe or Jane lottery winner whose life was ruined by winning the lottery has become a cliche. And I wish I would have taped this. Again, it was one of those financial shows on the radio where they interviewed people who had won the lottery. Now, this woman, I can't remember if she was 24 or 27 when she won $800,000. But 3 years later, it was all gone. Now, if she had taken Business 121 and in chapters 10, 11, 12, and 13 learned how she could have that money grow over time and pay her $2,000, $3,000 for the rest of her life. No, she took her friends and family to Disneyland and 1 week spent $45,000. Indeed. And now they have a television show about people who screw up their lives with lottery winnings. So, what would you do with a windfall? Slide number 60. These are the recommendations. From experts and from yours truly, change your lifestyle very little. Become one of the millionaires next door. Don't go out and buy all kinds of fancy clothes and flashy cars. Wear jeans and t-shirts. Be careful of acquiring a sense of responsibility for family and friends, and even strangers, because they will often expect you to share your windfall with them. What are you going to give me? Consider not touching the money for 6 months. Just put it away and find a trusted financial advisor. Whatever you do, realize that this is it. This is the one and only inheritance you will receive from your dear Grand Aunt Trudy. Don't squander it. Okay. Slide 62, the final slide, the final instruction regarding estate planning and for Business 121 Financial Planning and Money Management Summer 2015. Yeah, what's going to be the final instruction? You already know. Go see a lawyer. Get a good reference. Remember that none of this material was meant to be legal advice or recommendations in the state of California. And we're done. We are done Business 121. I want to take a few moments to tell you how proud and honored and happy I am and privileged I feel to have been your instructor for this class. If you remember at the beginning of the class, I told you that my goal, remember goal setting? My goal for this class is to be one of those few classes that you will remember from your college days as being one of the classes that really helped you, that you remembered 5, 10, 15 years from now as being one of those classes that really helped you in your journey, this crazy, absurd, joyful, sad, bizarre, long, strange trip. Also, I feel very privileged because in this country, in this capitalist system, power is concentrated in the hands of those with financial wherewithal. And so it's my hope that you become one of the powerful. But more importantly, I hope you find that you will use your financial resources, as the book says, to gain satisfaction, that you will be happy. So I wish you much success, much luck, and much happiness. Please stay in touch. I love to meet my students. In fact, I love to meet my online students eventually face to face. Please do not hesitate to contact me if you have any questions about finance or investments. I can talk about this a lot longer than most people would ever want to listen. If I don't know the answer, I'll go get it. As long as I'm still living and breathing, Wonder Professor will be up and running. So tell your friends and family that they don't have to take the class. They don't have to enroll in the class at Southwestern to learn the material. And again, I wish you much success. And lastly, no matter what you do in life, don't give up. Never give up. See ya!